Beautiful. So David, I'm just going to give you hosting rights. There we go. Over to you, David.
I'll just share this PowerPoint. Can everyone see that?
Yes.
All right. So welcome, ladies and gentlemen. Thank you for the introduction, Mark and Michelle. I'm here to talk about Comcare and email today. It's an area that I do specialise in, and mainly, well, pretty much across Australia. A tiny bit about myself before I kick off. Clearly, I'm a lawyer, but I was an AFP federal officer, a federal agent in the AFP for 15 years, where I was a lawyer as well, working in counter-terrorism and tactical response in various other areas and deploying overseas and those types of things. I'm a current military officer as well, so I'm a lawyer in the Army, where I defend people in court-martials. And I'm also an adjunct professor at the University of Canberra Law School and the ANU Law School, where I teach on a regular basis. So my interest is obviously the law, and but I essentially left the AFP because of my own injuries that I sustained in Afghanistan. 6 injuries. I got blown up in 2011 in Tarin Kowt, and you know that sort of spelled the end of my career with the AFP. But I'd sort of hung around for 4 or 5 years before making the leap into private practice. So and many of those injuries I had to fight for myself through the Comcare system. So I had to learn the hard way. So I've got a bit of an interesting story, but primarily I try to look after what really happened is I left the AFP, started up my own practice. I had 4 AFP members that I was looking after for their Comcare matters, and that soon turned into about 100 overnight. And then within a couple of years, it was 400, and then so on and so forth. So it's just gone on and on and on. There's about 7,000 AFP members Australia-wide. I also look after defence members through their DBA claims, so I'm fairly familiar with MERCA and DERCA and CIRCA and all the other acts that deal with injuries sustained by defence members. And now I'm also looking after all the other government, Commonwealth departments and ACT government departments down here in Canberra and Australia-wide. The ACT government's actually EML's taken over the contract from Comcare in the ACT government, but essentially it all comes under CIRCA, so which is the act in front of you that you can all see, not the act, but the title of the act in front of you. The reason for this presentation today is that I don't think that, well, and I can be corrected if I'm wrong, but I don't think that there's a great understanding of CIRCA or Comcare itself in relation to how it works. I mean, I think most practitioners or experts in your areas have got a great understanding of common law and how things work in some of the states and territories, but I don't think there's been much in terms of education around Comcare. And I have seen that sort of firsthand, where we've had to sort of go back to a number of experts on occasions and ask for supplementary reports because they either haven't understood the system or haven't understood what we wanted from our letter of instruction. So what I'm going to take you through today is 2 components. So we'll be looking at liability, so the initial liability of an injury through Comcare and EML, who both operate under CIRCA. And then the second component will be the permanent impairment assessment. So permanent impairment, as you know from your own assessments, is the end game for most of our clients and probably the ones that you see. But you cannot get permanent impairment unless you've got liability. So often that's challenged for various reasons by the agencies and Comcare. And one of them being that they've got responsibility primarily for people's injuries until they reach the age of 66 and a half. So it boils down to really a dollars and cents scenario, because Comcare and EML are essentially insurers. They've got a job to do, they've got their objectives, so I'm not here to criticise that, but I'm sort of here to give you an indication of what we see in the system and what we want to get out of the experts that we brief in our matters. Just following through the slides, so looking at liability claims, so Section 14 of the Act I'm not going to go into the actual specifics of the legislation, but Section 14 is the liability component. If a client that comes to me, whether it's a AFP member or whether it's a public servant, and they've got a claim that's been denied, which normally is the case, they'll come to me if it's been denied. We have to put in reconsideration requests through the agency, so through Comcare or EML. And that's a request of a decision to change their decision to deny liability. Now, normally at that point, we do it based on medicine and the law. Some clients don't have the funds to spend on an expert at that point. So we generally have to wait until we get into the Administrative Appeals Tribunal. So the Administrative Appeals Tribunal is the Commonwealth Tribunal, and it has jurisdiction over all circa matters, and incidentally MERCA under military, once it gets through the VRB process through DVA. So they've got the liability for that, they've got the jurisdiction for that. But there is internal review mechanisms within Comcare that you guys wouldn't necessarily see. You might see it in some of the paperwork that's attached to the letter of instructions, but generally speaking, you wouldn't see those reconsideration requests. That's something we do prior to the matter getting into the Administrative Appeals Tribunal. And then once it's in the Administrative Appeals Tribunal is generally when we brief you. So we get a letter of instruction out to the experts, depending on the injury, and we'll ask you to answer a number of questions, which I'll come to in a minute. And that's generally to get your opinion about whether or not that injury was significantly caused by the workplace. So we use the terminology that's in the legislation because it's there. If we don't use it, we're going to get some oppositional remarks from the respondent solicitor acting for Comcare and the Commonwealth and the ACT government. So we're very specific about our terminology. So when you see us write to you, and it's normally around prior to conciliation in the Administrative Appeals Tribunal, when you see us write to you, we'll be using terminology such as, in your expert opinion, do you believe that this injury, whether it's a back injury or whether it's a psychological injury, was significantly caused by the workplace? So that's the test for us. There's got to be a causal link between that injury and the workplace. If there's no causal link and you opine that there's no causal link, then there's no liability. So I'm sort of hoping that makes sense, because without that causal link, there's no point in going ahead with the claim, because it'll fall over. If you do opine that there's liability under Section 14 for an injury, then you've got to be really specific about it and follow the terminology. So yes, we believe that the injury was caused by the workplace and was a significant contribution. And the test it's not sort of beyond reasonable doubt in terms of significant contribution. It just has to be the more significant ingredient. So you might have things like prior existing injuries, or an injury that was asymptomatic, or a disease, but that can be aggravated or it can become symptomatic. And we see it with Shawman's disease, and apologies for the pronunciation, but I had an AFP member in Perth his job was to sit in a unmarked police vehicle, monitoring crime, so in covert services. And that vehicle was a diesel operated engine. So the car would vibrate, he would be slouched down in his car. He had Shawman's disease as a teenager, and it was asymptomatic, but that particular duty as an undercover operative led to an aggravation of the Shawman's disease, and Comcare accepted the liability for it, because they couldn't say that it was just Shawman's, because it was asymptomatic before it became symptomatic from the workplace causal link. So it's about looking at all those potentialities. Like yes, you have to look at all the clinical notes, because by the time it gets into the tribunal, you'll have this raft of material that you'll be looking at in terms of clinical notes, tribunal documents, medical reports from other practitioners in your field. We have to give you everything so that you can give, the fairest opinion you can give. It's because you're bound by the expert code of conduct, as you know. So we're not, I'm not presenting this to say to you today that, you need to give us all the answers that we're looking for. We're just asking for a fair report. We just want something that's right down the middle, or or just gives us an opinion either way. We'll often get reports back from experts that we fund that say no, there's no evidence of liability here because of A to Z. So this is arthritis or it's spondylosis. It's nothing to do with the workplace. So we just want frank and honest opinions from our experts, and we'll give you all the materials you need to do. Some of the pitfalls that we see in some of the reports that come back don't necessarily look at all the imaging that we give you, for example, or don't apply the appropriate tests under Comcare, so under the legislation, under CIRCA. So you just have to be cognizant of that, because the other expert that Comcare will brief, that often come from the same organisations as MAG or MLCOA, they'll have access to that same material. So if you haven't looked at it, or you haven't accessed it, or you haven't referred to it, and then they do, and the matter ends up in a contested situation in a hearing, then you're going to look a little bit silly, because they're going to say, well, why didn't you refer to it? So that's the reason why we send it to you. It's not just for looks, it's there to look at, read, assess, see whether it's relevant. If you don't think it is, then make sure you say it. We're not mind readers. We can't, you're the experts in your particular fields, be you orthopaedic surgeons or occupational physicians or psychiatrists. So therefore, it's up to you to opine, look, I did look at this document, but it had no relevance in terms of my opinion. If you do that, then you're covering yourself. Because if it goes to a contested matter and you're in cross-examination with a barrister, they're going to be asking those same questions to you. Why didn't you look at this document? And how did you come to that opinion? All right, so Section 14 is a liability section under the Act. And if you're granted Section 14 liability, so we're at the reconsideration stage, or internal review stage at Comcare, if they accept liability at that stage, then the applicant, the injured person gets Section 16 medicals all covered, so surgeries, medications, GP visits, etc. And then they get Section 19 incapacity payments, which pays them, essentially. They don't have to go through their leave. So this is really important for people. Not everyone's flushed with cash. There's a lot of pretty sad cases out there with people that can't afford to put food on the table. So this is really important to them. We see that here a lot. People that just struggle and have legitimate claims. So we obviously take our job very seriously. So this is what it means. If they get that liability, they can put food on the table and they can get medical assistance. So that's where those two sections come in. But if we don't get Section 14 and Comcare deny it, then all those other sections fall away. They lose their medical, they lose their incapacity payments and any potential permanent impairment assessments down the track. Now, generally speaking, with reconsiderations, they're very rarely accepted. So Comcare or EML very rarely change their decision once they've made a decision to deny liability at the initial go, which then means we've got to put an application into the Administrative Appeals Tribunal. They've got offices, and I'm sorry if you all know this, but they've got registries throughout Australia. So, we've got matters in Brisbane, Perth, Adelaide, Melbourne, Canberra. I think that's about it, and Sydney. So we're pretty much all over Australia with the work we do, because the AAT that you go to depends on where you live. So we often, because we've got clients all over Australia, someone calls up from Sydney, then we have to put the application in through Sydney. And they've all got sort of different ideas of how to run things, even though they're the same tribunal. But end of the day, the strategies are the same for me as an applicant solicitor running matters, and that is I've got to present the best case I can for my client. And often when we get to the tribunal, we're absent that medical opinion at that stage, because most of the medical opinions are lopsided. They're all in the favour of the insurer at that point. Not always, but mostly they're in favour of the insurer. So we've got to balance the ledger by getting a fair, not necessarily a fair opinion, but an opinion that's, a fair opinion. I'll keep it at fair, that looks at everything. Because those expert opinions prior to going to the tribunal don't see all the documentation that you would get having gone to the tribunal. Because once you go into the tribunal, you get all the documents from the client. So all the clinical notes, Section 70, 71 documents, so tribunal documents, and any medical expert report that's been done prior to the matter entering the tribunal. So it gives you the advantage of looking at all that material to provide your opinion, and probably gives you a bit of courage to provide an opinion that might be adverse to an opinion that denied that the injury was caused by the workplace. So don't feel afraid to provide that opinion if that's your opinion. You'll be backed up. Now, in terms of if we win in the tribunal and we get open liability, then there's those section 24 and 27 is where those permanent impairment assessments come in. So you'll be briefed either as liability, so for liability assessments. So we'll brief you to get an opinion on whether you believe that the workplace injury is a significant contribution to the actual injury. So that'll be one component, or you'll be briefed once liability is accepted in permanent impairment assessments, which is another area we see that often with experts they can fall down in, because you guys do so many different jurisdictions that I don't think Comcare is one of the ones that has the kind of appraisal that they can normally get in other areas, other states and legislations. That's just a rundown of what we do with liability claims. So we'll send you a letter of instruction that'll give you a background, it'll give you a factual matrix of what's happened to date. So we believe our letters of instructions are pretty good. We've spent years getting them really watertight. So we make sure we hit everything with those letters of instruction. And they'll have a reference to all the materials that we provide you in the pack. So I think most things are put on, uploaded to MAG's system electronically. So you'll get the letter of instruction, you'll get all the medical evidence, and you'll be asked to make an opinion. And generally it's about those key terms: causal link, significant contribution to the workplace. And then you give your opinion based on your expertise. And I've just gone through those key legal criteria, and you just need to be clear about what it means to get an injury under circa. So I provided you that essentially that's a cut and paste from the legislation itself. So when you're considering what an injury might be, it might be a primary injury, like a frank injury. If you're looking at physical injuries, it may be a disease, depending on what we're looking at. I remember having an AFP guy that had 10 diseases from working in the tropics, like Bartonella and all sorts of other nasties that he contracted, I think from Elcho Island. So it might be that, or it might be a frank injury, or it might be an aggravation. You would have recalled that I was talking about aggravation previously. Now, an aggravation is treated in the same way as a primary injury. If you can show as experts that the particular injury we're looking at, whilst it might not be a primary injury, is an aggravation of a pre-existing injury caused by the workplace, that's still accepted as being caused by the workplace. Where it's not accepted as a workplace injury, it's because the experts, so you guys, opine that this was pre-existing and the workplace had no contribution. So and obviously that's within your remit. You're entitled to say that if you believe that.
Say that again.
Yeah. Oh, sorry, did someone ask a question? Okay. Sorry, someone's got an open mic, so it's a little bit distracting. But looking at the reasonable administrative action component and done in a reasonable manner, that's often one of the defences that Comcare and EML will throw up in the Administrative Appeals Tribunal, and it's mainly for you experts that are psychiatrists. So RAA is a big one in terms of bullying and harassment. So we'll often get clients here that come and tell us that they've been bullied and harassed in the workplace, and the employer will come back and say, well, no, that person was just given reasonable directions to do something, or told to move desks, or were performance managed and didn't like what they heard, those types of things. So the respondent will always have that kind of defence, whereas our instructions will be, well, no, I was bullied and harassed. I was not given sufficient work. I was given too much work. I was not told that it was going to be a formal counselling session, and I was just ambushed. They're the types of scenarios that you look at for reasonable administrative action. So for all the psychiatrists out there, that's the sort of depths you need to dive into when you're looking at whether or not the employer's actions were reasonable or not. We see this a lot, so aggravation versus exacerbation. So I just want to be really, really clear that now that we've just gone through what aggravation is under the legislation, so you've seen that. So it's an accepted injury. Aggravation of a physical or mental injury is accepted by Comcare. If you use the word exacerbation, it's normally not, because exacerbation is more temporary. And we often see experts, they'll use exacerbation and aggravation in a medical expert assessment, which becomes a bit problematic for us, because then we've got to go back to you and ask you which one you meant. Or did you mean both, or did you mean one or the other? Because with the circa stuff that you'll do with Comcare and EML, if you get briefed by us, if you call an injury an exacerbation and meant aggravation, and you stick with exacerbation, it means the claim's going to get denied. Your report's going to be useless for the applicant. If you meant exacerbation, then that's fair enough. That'll mean the claim's gone, but you're giving an honest opinion that this was more of a temporary injury that should have resolved within a few months. But if it's aggravation that you meant, and it's more sort of long-term, then give that opinion, stand by it. I mean, you don't have crystal balls. You can't predict how long someone's going to take to recover from a particular injury. So you're not going to be held to any huge account if you say that an injury is an aggravation, if that's what you opine at the time and someone recovers in a shorter period. All you're doing is giving your opinion. But obviously you can see the downstream effects of getting exacerbation mixed up with aggravation. Aggravation's the best case scenario for the applicants. Exacerbation's not. It pretty much cuts the claim out. So if it's exacerbation you mean, and you meant to opine that because you don't think that the applicant or the client that you're seeing is still suffering from that particular injury, and it's become an old age thing, then absolutely opine that. But if you think it's an aggravation and they're still suffering from that aggravation in the workplace, then opine it. Stand by your opinion. That's all I'd ask. This is just something about physical and frank injuries, and so I don't really know what the demographic is of the audience in terms of experts listening at the moment, but I know this is being recorded. So the physical and frank injuries. Now, the main experts that we use for physical injuries are orthopaedic surgeons, and don't ask me why, but it just seems that they're our main go-to in most circumstances. So. And we find that the physical or frank injuries that are fairly easy to prove. So if someone breaks a leg in the workplace and there's an incident report put in, everything's tickety-boo, then great. That's really easy to prove. So it's quite refreshing getting those matters, but they're not always that black and white. Well, I've had matters in here where people have gone home after a long week at work, and then 2 days later they've fallen over or got out of bed and their back's gone on them. So they're the more difficult ones to prove. So we try and look at the clinical history or if they've put in any incident reports and at work. But so we can sort of do our due diligence there, but then it's up to the experts like yourselves who are assessing these types of injuries to say, well, you know what, there was no back injury previously. The patient themselves hadn't done anything laborious in that 2 days, from the Friday through to the Monday, hadn't gone hiking, hadn't played football, never had previous injuries to that particular part of their body. It's therefore fair to say, because of the duties at work, because they're on the jackhammer every day, that it's being caused by the workplace. So that's a sort of investigative assessment that you've got to make if there's a bit of uncertainty around complex matters where injuries come a bit later. I've mentioned there that MRIs and X-rays should be looked at as well in terms of causation. So in terms of examining whether the workplace has caused the injury, and that's a big hitter for us. We'll often see the mistakes from the respondent experts, on occasions where their experts haven't looked at X-rays or MRIs, and ours have, because that's our due diligence. We make sure that they see all the materials. So that's often where opinions will fall over if they haven't referred to MRIs or X-rays when they've opined that this is just simply spondylosis. So often we'll get that from respondent experts. They'll make that opinion without any reference at all to the X-rays and the MRIs, and it kind of makes our job a bit easier because we'll just send our person off for either an updated MRI or X-ray, or just show the tribunal the X-ray MRI that shows that this isn't a pre-existing type injury. And I've mentioned previously Comcare's attitude towards blaming and emails in trying to apportion blame to pre-existing injuries or genetics. I often see experts use smoking and obesity to sort of answer reasons for injuries or provide evidence as to injuries being that the person's a smoker and obese, and there's probably some fairly good science in that, but you have to be able to prove that, obviously, and there's a lot of research there. It's not my field, but they're often ones that I'll see where there's blame apportioned to outside influences not related to the workplace. So I've got a bus driver, for example, that gets injured because the seats go up and down on the bus, and over the course of a number of years, he ended up with a lumbar spine injury. I remember seeing an expert come back from the other side on that, blaming it all on obesity and smoking. Now, the guy wasn't exactly the fittest bloke in the world, but he wasn't huge. But I understand there is some science out there around obesity and smoking and the effects on other parts of the body. But you've got to be able to prove that. And then you've got to be able to disprove the mechanics and robotics of a bus going up and down over the course of many, many years on roads that aren't necessarily fantastic. So that all comes down to the investigative nature of the experts that assess. So if you do that thorough assessment, then you're not going to get please explains from us through supplementary reports, but you're going to be held in higher regard anyway in the tribunal, because they're saying that you're providing meaningful expert reports as opposed to ones that you just roll the arm over to get paid. I'm not trying to be offensive, but we do often see reports, and I'm not saying it's from MAG, but we often see reports where the arms just rolled over and opinions given. They're very short and sweet, and we actually don't know how you got to that opinion. So I think it's super important to make sure that you back up what you're saying. I'll read through these comments at the end if you don't mind, just so that I can get through the webinar, and then I'll try and answer those questions just orally if you don't mind. For the psychiatrists out there, we're often seeing a lot more sort of mental injuries in the workplace. So clearly my work with police and defence and other public servants and emergency services, we see a lot of PTSD type injuries. They're more difficult to prove depending on what agency you're at or what agency is writing the employer statement once the matter goes into the tribunal. Some agencies are better than others, but really, if you're a psychiatrist in this field with mental injuries, then it is a bit of an art trying to look back. It's probably even more important to look back at the investigative material in terms of the clinical notes and any pre-existing experiences as a child, or any trauma from childhood, or any particular mental injuries previously when you're examining one of our clients, for example. But generally speaking, with most of the people that we get, they sit a pre-medical with the employment agency. So that's a starting point for us when we get someone through the door. If there's no example in there or no tick and flick of a mental injury, or they've had no clinical assessment of mental injury or diagnosis, then it can be a fairly sort of black and white case. It's a but-for test. But-for hadn't this person done policing, for example, and scraped bodies off the road and cut people out of trees, then they wouldn't have ended up with PTSD or mental injuries. In other cases, however, you might get someone who's got bipolar disorder and had it since they were kids, and the workplace. A lot of experts will opine that the workplace hasn't contributed to the mental injury. In fact, it's just a continuation of the bipolar, for example, and that this person's resilience levels have never been up there in terms of being able to remain in the workplace and be robust. So yeah, we find mental injuries a lot tougher to try and deal with, and they're the majority of the ones that will be appealed. Sorry, I'm just going to get someone to turn off the heating in here.
Yes,
Plastic surgeon.
right.
I've been asked to have a look at you because of your facial injuries.
Sorry, say it again.
Bone and eye socket.
Excuse me, the gentleman who's on the phone, the plastic surgeon talking with someone, would you please mute your microphone? Everybody can hear your conversation and it's interrupting the presentation, please.
Thanks for that, Michelle. I wasn't sure whether someone was trying to ask me a question or not. Okay, so I mean, the test for psychiatrists is a little bit more difficult than trying to prove physical injuries. So, but again, it's totally fine for a mental injury to be aggravated by an incident in the workplace. And we often get major depressive disorders with people that, you know, an aggravation of MDD. You might get aggravation of PTSD, for example, where children have suffered from a PTSD type injury in the workplace. Sorry, you know, in their upbringing. So can you turn that heater off, please? It's really super hot in here. I'm just in a webinar. Sorry. Yeah, so often we'll see that where children have had adverse experiences, traumatic experiences in them growing up. And then they'll have a period of recovery, they'll go into the workplace, and then something will trigger in the workplace that isn't reasonable administrative action, then they end up with what is termed an aggravation. So that's acceptable. It's okay, because everyone's got baggage, everyone's been brought up in different manners, so we all carry certain problems or minor traumas from growing up, and that's completely fine. And we all go through, not all of us, but people have marriage breakups, relationship breakdowns, deaths in the family. They're all things that are considered quite normal in the passage of life. So they're not normally going to be things that will stop someone from getting an injury, a mental injury, accepted. It's more the case that if they've got a really pervasive mental injury that's been around for a long time, it's going to be more the case that is going to be hard to show that something like that is a primary injury for the point of circa in section 14. So yeah, tough job for psychiatrists in terms of assessments, but not always. And a lot of it will come down to that pre-medical that clients that you'll speak to would have had, particularly around the AFP or defence or emergency services. They're really quite anal about putting these types of clients or members through the ringer with those types of medical assessments. So head to toe and lots of mental questionnaires, and have to, lots of honesty checks in terms of any pre-existing mental stuff going on. So that'll be your first test, is looking at, and our first test as well, is looking at the clinical notes, but also looking at those pre-medical reports that are done prior to someone entering into a Commonwealth or ACT department. I was going to say there too, so, and it's totally acceptable for someone to have multiple mental injuries. So you can have an adjustment disorder, you can have PTSD, you can have major depressive disorder. I mean, I've got people here that I've had liability accepted for PTSD, major depressive disorder, alcohol dependency, and then you might get things like bruxism that come out of it. For the dentist or dental experts listening to this as well, but that can be a tricky assessment with bruxism because normally it's secondary to the psych injury. That's the liability stuff. So, and normally the liability stuff is pretty good with experts. It's pretty black and white. You guys either sort of opine that it's a primary injury and it was caused by the workplace, or it's a aggravation of an injury and caused by the workplace, which is great for the applicant. Or you'll opine simply like this is just spondylosis, or it was an exacerbation, or it wasn't caused by the workplace. So, and that is all totally fine. So you can only assess on the material that's in front of you. You can't make things up. So, and you shouldn't, particularly with your reports are going to face a fair bit of scrutiny in the Administrative Appeals Tribunal, and it's become a fairly litigious jurisdiction too, because it's barristers on both sides. There's matters that have gone all the way to the High Court. So, it's probably in some respects probably a higher jurisdiction than many of the others that, like your basic local and districts and magistrates courts and Supreme Courts. It's probably I think has more of equivalency to the Supreme, because it really the next appeal from the Administrative Appeals Tribunal in a hearing is to the Federal Court, it's a real live jurisdiction that takes the matters very seriously, and it's very, very, very contested. The Commonwealth really fight hard, and the ACT government really fight hard against us as the applicants if they think that liability shouldn't be accepted, and they'll take it as far as they want to, essentially. And before I move on to PIs, and I'll just brush on it really quickly, is some of the matters that we see where Comcare and EML push back, like complex regional pain syndrome. So if you're going to opine that someone's, and you're a pain expert, if you're going to opine that someone's got CRPS, make sure you look at the Comcare guide on CRPS, because you have to have 8 signs present when you assess someone. And 1 or 2 of them are modelling of the skin, hot and cold temperatures, tingling, all that sort of thing. So you need to be across all that, but these are some of the types of injuries that Comcare will contest the most is complex regional pain syndrome, chronic fatigue syndrome is another one, and there's a couple of others that I can't think of at the moment, but they're the ones that they'll contest a fair bit. So if you're going to assess somebody with that, make sure you look at all the evidence, particularly if it's going to be favourable for the applicant, do a full history. Now, in terms of PI assessments, and I've been talking for a fair bit, and I have to get moving in probably 30, 40 minutes or so to go to ANU. But moving on to the PI assessments, this is the end game. So Section 14 liability, which is what we just spoke about for the last half an hour or so, is the starting game. So if we get Section 14 liability, whether it's through a contested hearing in the AAT, and the tribunal saying yes, liability is accepted, we think that the applicant's right, or whether it's simply through Comcare accepting liability first blush, which you'll often get, then we go to permanent impairment assessments. So all the Comcare claims are assessed under the Comcare guide. I've put a link in there for you, Michelle, and Mark, to share with your experts. I mean, I get one printed out and sent to me. So, and then I know that when I'm doing a letter of instruction, I'll hold up a bit closer, but I know that when I'm doing a letter of instruction, I'm using both the right table. And there's really only one guide for the work I do. But then I also know that I'm using the right table. So it's pretty user-friendly. If you're assessing for a shoulder, you just go to the index and you look through and you find shoulder. If you're assessing back, you'd assess back under whether it's cervical, thoracic, or lumbar. The tables are laid out there for you. Often we'll get clients in here, police that will injure all 3 levels of their back. So you have to use 9.15, 9.16, and 9.17 and do your assessments under those tables for the PI assessments.
Thanks, David. We have copies of those in our main rooms, and we also have a specialist resource library. So if any of our specialists want them, we can provide those. But thank you for that link. I'll make sure that people know about that.
Yeah, no problems. I mean, it's the reason I'm mentioning this part as well is because it's often experts will go straight to the AMA 5 or AMA 6, I think it is now, but correct me if I'm wrong, I think it's AMA 5. And which is fine, but it's not fine in terms of going straight to it. You've got to use the Comcare guide first with matters that we brief in with Comcare and EML. So if you're going to do Commonwealth injury matters or Comcare or EML injury matters, then you've got to use that guide first. If you don't find what you're looking for in that guide, then by all means you can go to AMA 5 or AMA 6 and look for the equivalent table or whatever table you're looking for that particular injury. I've had matters where there's been nothing in the guide and nothing in the AMAs, and experts have had to go to clinical judgment. So you can do that as well, but generally speaking, you'll find what you need in that Comcare guide. So to permanent impairment, make sure you use that, and then if you can't find what you're looking for in that, then you can go to the AMAs. Often people will go to the AMAs if they don't opine that it's complex regional pain syndrome, for example, and actually opine that it's chronic pain syndrome, which is not in the guide, but it's in the AMA. So that's probably a sort of reasonable example. So use that guide when you're assessing. Now, to get for a punter in our scheme to get compensation under permanent impairment, they've got to generally get over the 10% threshold WPI, whole person impairment. So by all means, if you don't think someone's reached that threshold, opine it. You can give 8 or whatever the guide dictates. But if you think you can get someone to 10% or above, then make sure you give them that, but also give evidence as to why you think that person either reaches that threshold or exceeds it. So with your psych claims, for example, for PTSD under table 5 of the guide, or 5.1, people that have been admitted into South Coast Private, for example, or one of those, or St John of God, for PTSD or psych injuries from the workplace where there's liability, they generally start around 25 to 30% whole person impairment, because part of the criteria is you've got to have been admitted. So, and so on and so forth. Some of the other, for physical injuries, there's got to be presence of radiculopathy and other components for people to reach over the 10%. So you've got to use the guide like your Bible when it comes to matters where you're assessing under Comcare. I've just given you an example there for the psychiatrists listening into this of what I just spoke about. And it's really important when psychiatrists are assessing people for permanent impairment that they look at the activities of daily living, whether someone's able to do any of those things or whether they need assistance. I won't go through them just for the purpose of time, but this is what you'll find in the guide. This is directly pinched from the guide. But they're the sort of things that you need to really question your client about, not the client, but the patient about, whether they can do any of those things and if they need help with them, because that's going to lead to, the type of PI that you give them. That's an example of the guides that we use under Comcare with Circa. So obviously 0 and 5%, you get 0 for a mental injury, but 10% is your buy-in. So that's where you start. And generally speaking, most people that I've seen mental injuries that come here will get 10%, at least 10% WPI. Not all, some of them won't. It just depends on what you guys opine. And I've put 30 in there because hospital discharges and daily medication for someone who's got a severe enough mental injury that they need to be put into a mental institution. And they're just some of the notes to the table. So it's important to read, particularly if you're a psychiatrist, you need to work out who's an appropriate person, who's a suitable person in terms of supervising somebody with a mental injury, and who's a suitably qualified person. So that's generally a GP or a psychiatrist. Psychologists don't necessarily factor in there because the psychiatrists are the ones that can give out medication, as you know, and can give directions on how someone should try and get through their day. So it's really important to hit those key points if you're assessing for a mental injury. There's some of the things that this is for a physical injury, this one. So these are the sort of things you need to look at. And I think this is for hands or fingers or something like that. So, but it's also for upper extremity impairment. So you'll get a letter of instruction from us. And if it's for a shoulder, for example, someone's had multiple shoulder surgeries on both sides, often you'll get us asking you also to assess for upper extremity where someone's, upper extremity impairments, because clearly your arms and your hands are your grabbers, and if your grabbers aren't working, then that's your upper extremity. And it's fair to say that if you lose full range of movement of both your shoulders, then you're losing that upper extremity control. So you can actually assess for whole person impairment under a number of different tables on the one injury. The art in that is for us to put that in our letter of instruction. All right, there are some of the tables for that I just put in there for example. So 9.8 is hands and fingers, and 9.81 deals with abnormal motion of digits. That's a real sort of awful slide, but that's the combined values chart. So if you get asked to look at the combined values chart, that's because there's probably multiple injuries that have been caused from the one incident in the workplace. So if someone trips and falls over at work, breaks a leg, breaks an ankle, and dislocates a hip, yes, we could ask you to assess under each individual table, because there's a hip table, there's an ankle table, and there's a knee table or a leg table. But you might be asked also to do a combined values chart assessment, which means combine all those assessments together. And that's particularly useful in circumstances where you think the whole person impairment for one particular injury is under the 10%. This can actually boost them over the line. Again, Comcare, whilst this is in their guide, they don't particularly like combined values chart. There's the case of Canute where they say that every injury should be individually assessed, which is true. But the combined values assessment chart is there, or the combined values chart is there for use in those circumstances. So don't be afraid to use it to combine each injury that's before you, provided that injury was caused in the one incident. That's very important. That's just a summary of what I just spoke about. We'll generally speaking, we'll give you appropriate tables. There is a lower extremity table as well. So you might be a knee expert or an ankle expert or back expert or whatever you might be. We will give you the appropriate tables for that particular injury, and there might be a number of them. So you just got to make sure you're assessed under each one. I've said all that. These are just some observations that I've seen in the last 7 years in private practice. These are some of the errors that we see. So inaccurate recording of history from the client, not reading all the materials, so which I spoke about earlier. That'll come out in a hearing. They'll just be saying, well, you were given all these materials, why didn't you read it? Well, no, I was too busy, or I had back-to-back assessments, and it's just not going to be, it won't wash in the tribunal, and it won't wash in the federal court when it gets appealed into there as well. So it's in our area of injury, workers' comp, you're playing for big bucks, because the matter will just get appealed, and it'll get appealed onto the federal court. And if Comcare aren't happy in the federal court, it'll get appealed to the full federal court. And if they lose again, they may even appeal it to the High Court. So you'll be dragged along the way for the journey as the expert on the record. So it's really worth mentioning that that you make sure that everything you do when it comes to assessing a patient is accurate. You've read everything and you've done what you've asked for in the letter of instruction. So if we're asking you to assess somebody for liability for a particular injury, you've got to demonstrate, yes, there was a significant contribution by the workplace that caused this injury, and this is what the injury is, and this is what treatment the person should get. And if you have to, no, I don't agree with Dr. Bloggs, who said that, this is pre-existing, when there's no evidence to show there was anything pre-existing. Be brave about sticking to your opinion. It's really important if you believe that your opinion is stronger over, because you're going to be coming up against colleagues, when you give your expert assessments. And that's just the nature of the beast. And it's a fairly small industry, unfortunately. Spelling the client's name correctly, it's a bit of a no-brainer, and then ensuring key dates. We've had several reports through multiple different assessment centres that will just give us wrong dates, even though we've supplied you with the correct dates. And dates are important for this line of work, because date of injury is critical. If we get that wrong, or our experts get it wrong, then it's going to be absolutely criticised in the tribunal. We can lose matters over incorrect dates of injury. So really important. That's about it from me, Michelle. I know I spoke, fairly broadly about things. I can look at these questions if you like.
That's right. So firstly, I'd just like to say thank you very much on behalf of MAG. Although, yes, you did speak for a long time. Actually, it was really interesting. I certainly reflected on a lot of the things that you've said, which is often feedback that we receive also from our law firm clients. So it is really important to convey this, because our specialists are, I believe, the best. But anytime any of us can reflect on what we do and sort of make sure that we continue to be at the top of our game is awesome. So thank you so much. I note that there's only one question written here, and that's from Dr. Das, who talks about the definition of one person's bullying being another person's, performance management, etc. Have you had a look at that question there, David?
Yeah. I'm happy to answer that. So we had if he wants to have a look at the case of O'Callaghan, that was a case that we took to the tribunal and won in a contested hearing. And that was a police officer that was given formal counselling by the officer in charge of a police station down here in Canberra, in the Australian Federal Police. And he was given no time to turn up. He was given no paperwork until he walked in. He was given 30 seconds to read a coronial, which would have taken anyone who was quite normal probably a couple of hours, and the door was left wide open. And he was absolutely criticised for these poor standards of work. This is the first he'd heard of it. So normally there's a couple of steps. Normally it's informal counselling, then it goes to formal counselling. They completely bypassed the informal counselling component and went straight to formal counselling, didn't offer him a support person, and essentially ambushed him. So I get what Dr. Das is saying, absolutely, and sometimes it's in the mind of the beholder, and so the real legal work for us is to look at what the policies around informal and formal counselling, what they're entitled to, what should happen, and if one or two of those things don't happen, then generally speaking, we can get it kiboshed in terms of that process, because that's unreasonable administrative action, or it's reasonable administrative action done in an unreasonable manner, and that'll mean that defence will fall over. Comcare's defence.
Yep. Look, thank you so much. Can I ask if
because they haven't been reasonable? It's a
sorry.
reasonable person test. And you go, Michelle.
I was just going to say, can I ask if on the page that we're at currently under observations, whether the typo was ironic or whether you were hoping someone would pick it up?
Receive.
If you're like me, you will have done that deliberately.
Which one's that?
Sorry. Misspelling of the word receive.
Or I might have just missed it. But if there is a typo, my apologies. I'll probably just
claim it. Claim it as deliberate. You put it in there to catch someone. Sorry to interrupt you, David.
No, I'm too honest. No, it's a bit of a typo. So. No, it's okay. And it's,
right.
See, I'm often the villain of typographic errors.
Look, once again, thank you so much for your time.
But yeah, I mean, those observations stand, obviously. I mean,
does anyone else have any questions they would like to ask of David?
No.
This isn't so much a question, but just a general comment. To the psychiatrists out there, under the circa legislation with psychiatric injuries, if you can disentangle different psychiatric conditions and separately assess them, following a couple of cases in the High Court and that I ran, you can actually get multiple payments for psychiatric injuries, provided you can give them clear signs and symptoms as attributable to each of those psychiatric conditions. Now, that is completely different to when you're dealing with MERCA under the military compensation, where they'll treat all the psych injuries as one in terms of assessment of impairment points. However, with MERCA, if you've got conditions that can't be attributable to service, it can end up with apportionment of the psychiatric condition. But under circa, you can get paid. So if you get 10% for depression, you get paid. You get 10% for PTSD, you get paid. So you can have multiple payments for various psychiatric injuries. So I just thought I'd throw that in as an observation to everyone.
And that's really spot on, if I can jump in there, because I've had coppers here that have gone down to psychiatrist we use in Melbourne, and I think he ended up with a 50% WPI, 25% for MDD, and 25% for PTSD. So you're absolutely correct with Comcare. Mercer and DVA is a bit of a different beast, but I actually find there's a lot of delay with DVA, but I actually find if I push them at it into the VRB, almost 7 or 8 out of 10 times, I'll get what I'm after. Whereas with Comcare, they'll fight us and fight us and fight us. I've never had to go beyond the VRB and DVA yet, because the appeal mechanism from VRB is the AAT. But you're absolutely correct about multiple psych injuries being accepted. The only difference will be the Section 27 non-economic component. You can't have 2 lots of suffering. So you'll just get one payment of the 27, but you might get, as you rightly said, multiple Section 24 payments for permanent impairment.
That is correct.
Yeah. Who's this speaking? Sorry, is this a lawyer, Brian? Is it
Brian Briggs.
Are you what's your area of expertise, Brian?
My official title is National Military Compensation Expert at Slater and Gordon.
Oh, right. I didn't know I had someone else listening in from another firm.
No, I always sit in on these things when it's of interest. And, well, you know, with respect, David, I knew all of what you were telling me, but it's always good to hear it again. So,
fine. I wish I'd known my audience. I might have been a bit more careful, but no.
I did tell you what the audience would be made up of, David.
I didn't know there was going to be a law firm in here, but that's all right. I don't think I've said anything that's incorrect. But
no. I just thought I'd throw that observation in for the psychiatrists out there.
Mm.
And the court of the decision of Canute that you referred to was followed up by fellows. And with lower limbs, for example, I've had clients where I've gotten 8 separate lower limb payments under CIRCA/DIRCA for every individual. So both ankles, both shin splints, both knees, both hips, both plantar. So you can have multiple lower limb conditions, provided you can treat them in the prism of the own injury as a fit and healthy person, where you disregard all the other injuries and you just assess that injury. It gets messy, but it can be done.
Yeah, absolutely. And it's our job as lawyers is to make sure that we get as much as we can for our clients, and often come to me with just PTSD. And then as I start talking to them, they've got alcohol dependency, they've got impotency, or I'm just trying to think what it's called under the Comcare Act, but
sexual dysfunction, erectile dysfunction.
Erectile dysfunction, yeah. And then there's, it's the art's in, assessing your client and making sure that you get out everything you do. So I call it the paddock to plate. So that's our job, and then obviously, then it's the expert's job to do all the individual assessments.
I know, David, you commented about bruxism, and you always want to have that in the mix, because dental work can be very expensive, as we all know, but ultimately it won't lead to a permanent impairment assessment, because it can be treated and you can get, teeth replaced and capped and dentures, etc. But you certainly want it in the mix for liability, so you get that access to the medical treatment.
Yeah, we've got one in the tribunal at the moment for a AFP person, so the Comcare are fighting it. But it gets a bit tricky about which expert to use, whether it's psychiatrist or whether it's a dentist or an expert in orthodontics. But depends on the primary injury.
With the Commonwealth Public Servants and CIRCA, as you were saying, that Comcare likes to fight things, and they love the reasonable administrative action defence. We don't see it that often in the military sphere, because, you don't have that bullying and harassment. It goes to a whole new level in the military, and normally you'll have physical and psychiatric injuries due to service in warlike, etc., etc. But I enjoyed that. That was good.
Well, my own personal experience, no worries. My own personal experience was Afghanistan. I got blown up in a rocket attack in Tarin Kowt after my 3rd rotation. So I ended up with 6 injuries: spinal, swelling on the brain, PTSD, various injuries, hearing loss. So yeah, and I had to pretty much just fight those myself, because I really couldn't find anyone at that point in time in 2011 to assist me. So I just did, and I was already a lawyer, well and truly a lawyer by then. So I just had to self-rep.
You didn't Google search me, because I've been doing it since 2008. So
probably should have, mate. But but that's how I got into it, because it's a travesty the way that our veterans are treated, and that's where my passion is, looking after veterans and others, public servants. But I do less paper cuts. I do more, more serious type injuries to people. So anyway, that's where
I hope you got assessed at 80 impairment points under Mercer.
Mate, I did actually. So I've got a gold card. But yeah, no, I did okay out of it, but a lot of my colleagues haven't. So that's my passion. That's the reason I do this work. It's because I want to really look after people that deserve it. And I see that, you know, Comcare and DVA are always are fairly oppositional. It's really difficult to swallow for me, I've got to say.
It's good to have you on the team, because this is not an area, as you might have mentioned, lawyers don't necessarily get involved in this area that much because it's not sexy and it doesn't make lots of money. So lawyers will not, they will do Comcare, but military compensation lawyers are few and far between. So everyone in the game I love, because there's not that many of us doing it.
There isn't. There's Dave Lander, but I mean, I when I first started, it was with Alan Anforth, so he was my mentor. And you probably have heard of Alan. He's written books on it. So.
Yeah, I know Alan.
Yeah,
I've actually used him in matters as counsel, etc.
Yeah, he's amazing. So we've got good people that help us out. So I don't think we're alone. It can be a pretty lonely business doing this because there's more respondent work. There's lots of firms that want to look after the government and suck the tit of the cow, but we're not necessarily in that bracket. We look after the little person. That's how I roll. I couldn't do it any other way.
And unfortunately, the government has deep pockets, so they can spend millions on external law firms and senior counsel. And as you said, they will take it to the federal and high court if they lose. So
absolutely.
Gentlemen, we might have to wrap this up only
right.
because we've taken quite a little bit longer time than we normally do. I might put the two of you together if you don't mind. Share your contact details with each other. Again, thank you everybody for giving your time today. That's really been most valuable. Brian, your comments have also added very much value to this session. The recording will be available in a couple of days and will be sent out to you by Sophia, and look forward to our next seminar coming up. If any of you specialists who are listening would like to give a seminar yourselves at some stage on an area that you find interesting or that is topical to you, I'd really welcome you touch base with me to let me know about that. And yeah, let's do it again. Thank you again so much, everybody.
No worries. Thank you, Michelle. Thanks, Mark. Thanks for hosting.
I really
Bye-bye.
appreciate your time, David. And maybe we can get Brian and David doing the next one, and we'll throw them a few curly questions, because it is a space. It's not just in Australia. I'd note we're doing a little bit of work in other countries, and the way DVA and military people get looked after once they've served their country is probably not optimal. So whatever we can do to help and make that journey for the plaintiff or the applicant easier and more understood, we're always looking forward to providing that service. So thank you again, David, and thank you again, Brian, for your comments. Thank you, everyone, for your contribution today.
Have a great rest of the day, everybody.
See you guys.
Ta. Bye-bye.